Live, where I get the chance to chat with luminaries in e-discovery and related areas.
Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President, Brand Awareness at Reveal. Each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select Resources, then select eDiscovery Leaders Live. My guest this week is Lopp Mathias. Megan is the founder and managing partner of the Lopp Mathias law firm. She is busy with a number of additional roles as well, among them co-chair of the steering committee and technology subcommittee of the 7th Circuit Council on eDiscovery and Electronic Data, board member of YWCA of Metropolitan Chicago, a member of the American Bar Association Technology and Science Committee, and a board member and secretary of Lifespan. Megan has a JD from Chicago Kent College of Law and not one but two BAs, one in marketing and the other in international relations from Michigan State University. Megan, welcome.
Hi, thanks for having me.
Glad to have you here with us. Now let's see if I can not stumble over my tongue too much today as we go through this. I would like to start today looking at a little bit about what you do and how you go about doing it. In particular, the work you do with legal departments to help them, as I think of it, given how you described it to me, help them get from today to tomorrow.
Thank you. That's really a core part of what we do here. In my experience at other firms, as a partner at other firms, I found that there was clients needed a lot more than just legal. Even legal departments, they don't just need the legal work done. There's everything around what the work means and how it gets done. And so we will often be engaged by legal departments and even other law firms with regard to the process of providing legal services. So we help come in and look at the process, the workflows, the technologies they're using. Is there a better way to, manage contract management? How are they managing their legal spend, their outside counsel legal spend? So we sometimes say that we're outside counsel that operates like an inside counsel. So we can, some companies, we take over the law department and run it for them, sometimes as an interim process until they have the infrastructure built out, and then they bring in a new GC. That's sometimes called fractional GC work, although that sometimes has a connotation that I don't like, but it is a common term used for some of the work that we do. We can take, smaller companies, I say smaller, between 50 million and 500 million, and help stand up their legal department for them. And it's actually really exciting because you're not just providing legal. So we talk about it on our website, and some of the things we do is Legal Plus, because it's more than just giving you the legal services.
We sounds like a lot, and you are a fairly small organization. How do you manage all of that? You're not doing all of that yourself, right?
We are not, actually, and that's part of our business model. I also say we're a law firm that's not really a law firm, because we are we don't even have service partners. We use relationships, contracts, contractors. We have other firms. We have vendors that provide the flex. So if you might not need, maybe you have enough lawyers, but you need a pack of, paralegals to manage something. So we can bring through our relationships, a team that includes sometimes a COO, sometimes as a GC that also operates as a COO, plus, pack in the paralegals and get the workhorses in there. So it's more like we've built the business model to be able to offer you a legal department, or create, maybe it's a big project that you have a 12-month need and you don't want to hire people and then let them go. So we come in on those kind of projects too.
Part of what you do, I imagine, as all of this, is help them with their internal e-discovery needs. Tell me a bit about that.
Well, when I was with other firms, it became very clear that even the sophisticated clients didn't have a handle on e-discovery. So during my time and through my role at the 7th Circuit e-discovery pilot program, which we changed the name to the 7th Circuit Council on E-Discovery and Digital Information. That took us 6 months to come up with, by the way. But if you don't do it every day, you don't do it really. So if you're not in that business, it's something that while lawyers should be up to speed on it, between the technology and the rules, it's hard to stay abreast of new developments. So that was our role at the councils, to stay abreast, obviously offer education, that kind of thing. And we do that for companies. And so they may have a need, like a big litigation matter, or they may need us to come in and, as part of what we do, issue spot and say, do you even have a document retention process? What's your legal hold situation? So we come in and provide those services as well as help them obviously develop them, draft, their policies and also the documents that relate to that, and then come in on projects to help, manage, big e-discovery issues, which can save them hundreds of thousands of dollars by having someone that knows what they're doing manage that process versus trying to figure it out.
It's often said that there are 3 prongs to e-discovery when you're looking at, for example, what a corporation is going to do. Policy, of course, what policies have been developed and are in place. Practices, what are you actually doing or trying to doing and then people, who's doing all of this. Are you assisting corporations on all 3 fronts?
We are, and in the legal department, and as well as sometimes, like I said, it includes the executive services too, just depending on the size of the company. And that's part of what Legal Plus is, which is any lawyer can draft the policies, but you need someone that's helping you figure out, do you really need these kinds of people managing this particular kind of work? That's a people problem, but also a process issue. So we come in and we do assist companies with all of those pieces. And often they will rely on our team for a time frame just to see the difference. And then we help them. We don't stay in long term, or else I guess we'd just be one legal department. So we help them bridge the gap until they can, essentially recreate what we've done, including with technology.
And on the technology front, part of what the corporations need to do, once again, is figure out what technologies they might want to use, how to bring them in, and how to make effective use of them, or if they're not going to use them themselves, who to partner with on that. I gather that, yet again, that's something you're involved with?
It is part of kind of the managed services part of what we do. We have a number of vendors that we arrange that they contract directly with the client, because when we step out, we want it to be seamless. Or we have, we can utilize the services that, the technology that we have, and then decide if that's a good fit, and whether we, before they have to contract directly and really redo their systems in order to accommodate the new tech. So we try to come in early. We do a document audit sometimes, a process audit, a people audit, and a technology audit to see what they're doing. There's often like technologies that nobody even uses, and that saves them money to just wipe those out. Or there's functions within technology they already have and they just don't know how to use it, and use all those things and maybe become more efficient. And so there's lots of different scenarios that we come in and help with that.
It sounds as if on the technology front, part of the advantage of this approach for a corporation is that at least with specific types of products, e-discovery, for example, e-discovery software, they have a chance to test the software out on a system where you've got it up and running and implemented. And then if it turns out that that is the platform or those are the tools they want to use, then they can bring those up and running in their own environment.
Right. Yeah, that's really the best case. And that's why it makes a lot of sense. I feel like I'm tooting my own horn here, but it makes a lot of sense to have someone that knows the tools. We love Reveal, by the way, but people that know the tools and that the functionality that they need for that particular client need. And really then they don't have to go through cycles of checking other technologies over a long period of time. We can at least shorten that and help get through that process, hopefully more painlessly.
From what you're saying, I gather that in many ways you are helping these organizations get up and running with respect to the functions you deal with. But the idea isn't for you to stay there forever. It's for you to help them get going, and then you hand off, they take it from there. Is there an average length of these engagements or some sort of bell curve distribution?
We like an 18-month engagement because it takes some time to get to know the people, the processes, and their policies, obviously, and so there's also then the learning curve of their staff. If they haven't, they're going to have them. So their staff, and then implementation. We don't just drop it and leave. We want it to work. We want to, flush out the issues. So, and there will be issues, especially if they have employees all over the world, and we have to make sure everybody's been onboarded properly with regard to the new tech or the new process. Sometimes we talk about innovation. It's not even maybe not technology. It might be just how you're dealing with it within your department. So, but that's all, human based. So, we factor that in, and we really do prefer the 18-month because we get the best results in that way.
Yeah, you're right. Innovation can take many forms. It's not just the tools you use. It can be the pricing models you use, for example. Is there anything in particular you're offering companies on pricing models of interest?
Absolutely. So we will come in, and again, it was hard to do in a large firm environment that's institutional like, and they have their comp systems and other systems. One person just can't come in, and while novel and amazing, you're not going to change the entire way this law firm works because it filters through everything they do. So that's part of the reason I went and started my own firm, so that I could be that flexible. And so we'll get in there sometimes and say, look, I can, we've done enough where you can ballpark what this is going to look like. We offer sometimes flat rates, or put them on we call it a quarterback plan, where we stay in and we kind of true up after 6 months or so. We might put you on a 30 hours a month or 300 hours a month, and then realize 6 months later you need to be adjusted. So we do a true up. So they get a blended rate, which saves them a lot of money. So yeah, we try to be really flexible as it relates to that, because that's the whole point.
You have mentioned several times now what I will think of forever as the Seventh Circuit pilot project. I know the name has changed, but it was a pilot project for 10 years or something like that?
Right.
You've been active in that a long time. Tell me about your role with that with that group.
So we had teams, different committees, of course, and then we had a steering committee that helped with like vision and planning for the year and where the organization was going to go. And it includes judges, federal judges, state judges. We try to include all stakeholders, lawyers on all kinds of work, small cases, big cases, plaintiff's work, defense work. So we had, a broad, diverse input when we were creating the policies and principles that were largely adopted throughout the country in federal courts with regard to our model rules and things like that. It's really an exciting thing to be involved with essentially the experts in the nation on this issue. including some of the best judges, and people just the technology moves fast, and as you can imagine, the principals weren't necessarily keeping up. That's why it was a pilot program for so long. We were essentially chasing it for a long time. We changed the name because we thought we got to the point where we were no longer a pilot, and so we came up with the fancy name of ediscovery and digital information. And also offering things that were, I thought, really novel, like we did e-mediation services only on an e-discovery issue. So we're not going to try to help you settle your case, but when you come in with you have an e-discovery complex issue, the magistrate judges want us to help anyway because, again, it's not their daily business. So I thought that was really a great program that was offered for free to people in at least the Seventh Circuit courts. And that was really interesting and fun. And then we also had, CLE, we did lots of education. I personally did a few of the CLEs for judges without practitioners in the room, which was interesting because they would ask the real questions versus when there's practitioners in the room. I thought that was really interesting because they wanted to know, is that how much that really costs? Because that's what I'm hearing from, and you never know. The truth's probably somewhere in the middle, right? So those were really fun to me, those that education. Their website is really full of resources and information, case law on particular issues. Like I have a cell phone issue in Arizona, and you go to the website and they have all the relevant cases, which was a great resource for people.
As I recall, back when this first started as a pilot project, one scenario that people were talking about was that this would serve as a template for other circuits to then start their own projects. Did that happen? Was this so successful that there wasn't a need for other pilot projects in other circuits? How did that play out?
It really did. We became the shining star of e-discovery for a while when we came up with some of the model rules and even forms to use, and those were largely adopted around the country, and that was really the fun part, one of the fun parts as well, to be looked at as leading the way on that. So that naturally, when MIDP came around, a mandatory disclosure program, which changed entirely how we think about disclosing information, at least on my end, my 20 some years of practice. But, they look to us to help with that as well. So we did have people involved in helping roll out MIDP, at least in the Seventh Circuit.
So let's talk about that. Share with us your experiences dealing with mandatory disclosures and how that has changed over time.
Well, I think one of the challenges was, and I'm in this group, in civil litigation, you're used to just hiding the ball. That's like you fight about that. You're creative about that for years sometimes. So if the opposing counsel can't get the right request made or doesn't ask the right question, I get to hold that in my pocket, right? MIDP threw a wrench in that game plan, which is you have to disclose it without anyone asking, including harmful information. Like, okay. Now, the theory is to unclog the court system so you're not stuck fighting and doing this, posturing thing for years. So I get it. And we were tracking the numbers about whether, and they still do track it, about whether it was having an effect on the cases and how quickly they settle. But on the other side, now you have people fighting about you didn't disclose it instantly, because it's a lot. If you, even as a plaintiff, and the lawsuit's coming because you filed it, you have a lot of information to produce in a very short period of time. And then as a defendant, you just got sued, and you also have to get every document preserved instantly and then produce it in a very short period of time. And that, for me, it goes back to proportionality, which is that's a lot of work to put on in a case. And what if it's a case that doesn't have merit, and as a defendant, you have to go and spend all this money? The plaintiff has instant leverage because they then just the cost of having to preserve and produce could settle the case potentially. So, there was this going back and forth about whether that obligation should be stayed if there was a motion to dismiss pending in the case and that kind of thing. So that was, I think, still is. It's hard for people to change the mentality of we're going to, produce it now and the cost involved, and does that change it? It doesn't. It makes it harder. It's more expensive, and it has some impact on cases settling, I think.
So from the studies you've seen, the research you've seen or done, how effective do you think these mandatory disclosure requirements actually have been?
I don't think it had the effect that people thought it was, at least like the judges and the administration thought. I think it also has the effect, I'm in the trenches, right? So it has the effect of people, now we're dug in. You made me spend $50,000 and you have a meritless claim. Now we're probably going to have to try it, so I don't know if it necessarily had the effect that they thought it was, which is settling now to avoid that cost, is I think, the mentality that what they thought was going to happen. So I think it did have some impact, but now COVID's here. So it's, I think the data is going to be a little off.
So you helped with the preparation of the first round, if you will, of the mandatory disclosure requirements. You've had a chance to see how they work and don't work. What recommendations would you have for improvements to those?
I think that people shouldn't be caught in a gotcha. That doesn't mean you might be the person that should win this case. And if you messed up the e-discovery production, it should not be the thing that causes the settlement because you're worried about liability. I think what could be improved is give a little flexibility to lawyers and parties. There's a rule that you have to seasonably supplement within 30 days of getting a document, which if you're, again, that practitioner in the trenches, 30 days is nothing. I might get a document and I haven't looked at that file because I can't get to it for 3 weeks. And now I have 5 business days to produce it, right? And you need to think through, how does this impact my case? What does it mean? Do I have to include other witnesses? How is it preserved? Turning something over in a couple of weeks is tough.
Right.
So,
right. 30 days sounds like a lot of time, but it is not. Yeah, not in our world.
It wouldn't be a lot of time, but we don't have one case, right? So in theory, we hope to not have just one case. So I think it's tough for practitioners. And I think it also goes back to the proportionality piece, which is, should we have to do this in a case like this? So there's different, it's a different analysis if you're in a small case, for example.
So let's focus a little on proportionality. Proportionality has been core to the legal system and practice in the UK for a long, long time. It migrated slowly over to the US. It became a much more prominent component, at least in the federal system, with the most recent revisions to the federal rules. Several groups are working right now on materials trying to address the challenges of proportionality and how to address them effectively. What advice would you have for those groups?
I mean, everybody's working on that concept. I probably say that word every day, or most days I say that word. There's a lot of really great people working at, the Sedona conference, for example, and stuff like that. So on these principles. And I think while you would think it brings clarity, it doesn't. There's a lot that goes into that word and that concept as it relates to e-discovery. I think I'm definitely not the expert, but I on that, because I know there are people who are way deeper into it, but at the Sedona conference in particular, but I think proportionality should be the leading principle in everything we do. It changes how you approach what's a appropriate response. How much do I preserve? Do I include the unallocated space of these devices, even though the rules have changed on that piece? But That I just dated myself by saying that, I think.
Yes,
You know,
if there is even such a thing as unallocated space
yeah,
in the drive you're dealing with, if you're dealing with a drive.
right.
Right.
So, I think there's a lot of work to be done, but I do think that proportionality is sort of, it should be the driving principle, because it can change how you start step one in the case.
Let's switch gears a little bit again and talk about grit. You and I chatted about grit as we were trying to figure out where we would go with this ahead of time. And that came up in the discussion. Tell me about the role and the value of grit in what we do.
I think grit, I was mentioning too, I think grit is what I hire for, because I say I can train you to be a good lawyer and a great, fantastic litigator. But if you don't have grit, I can't really, I can't teach you that. That is something you either come in with or not. And I think it impacts people who, even including people who get into e-discovery. It's kind of a unique personality trait that you have to want to tackle this kind of a complex issue, I think, and enjoy it. To be good at it, you should enjoy it. And grit, I think, impacts me as a leader. It's made me a better leader, I think. I think my story and my life is really what led me here. I'm a first generation college student. My mom was on a dirt road in a small town, and she thinks I'm nuts for living in Chicago and running a law firm. But, but a lot of that is grit. It's getting through it and learning how to navigate it, which is exactly what we have to do in e-discovery, which is, this can be big, massive, complex problem that it hurts your brain to start thinking about. And we have to get through it and find an answer. So I think grit is so important, just in terms of quality leaders and lawyers, but also especially in e-discovery. It's kind of like part of the deal.
No grit, no good.
Yeah, exactly right.
I've got one final question for you, which is my ideal e-discovery platform question. It goes like this. What would your ideal e-discovery platform look like? Assume everything is possible. Assume there are no technological, financial, or any other limits.
Oh, this is good.
What would you want?
I would want it to be free, because it is unfair and unjust in my mind for people who can afford fantastic tools, which then reduces their legal fees because the tool does a lot of the work, versus, I say people, but companies that often can't even, dedicate the resources to it. And so we have to be super creative as to how we get through that process. I think that access to justice generally, that'll lead us down a whole different road. But generally, people, the process is so expensive that people are often left in the cold, companies included, because it's an expensive process. I think having it widely available, easier to understand what the different functionalities are the different tools, and something that's more readily available, to not just for one case. Like, I would love all my cases to be up inside the Reveal tool every day, because then you're not packing in the work in the last 6 months of a case. I think that would be ideal. And I also think that if it could essentially crawl, in terms of like a litigation hold process, it crawls the system with the parameters you say it, give it, helping the litigation hold process, because human error ends up being a lot of the issues we see, and often technology can be a solution or helpful. I think that would be something really a game changer, really.
Great. Well, I don't think I can promise you free.
Right.
We'll try to work on the rest of the pieces. Thank you very much, Megan. Megan Lopp Mathias is the founder and managing partner of Lopp Mathias Law. She's been so kind and gracious to join us this week. My guest next week, March 19th, will be Elon Shear of DLA Piper. Thanks again, Megan.
Sure. Thank you so much for your time. This was fun.